Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, and Salam Kebajikan to all of us.
Good morning, ladies and gentlemen. Welcome to the day 2 of the conference and the plenary sessions of the 6th International Conference on Law and Governance in a Global Context, presented by the Faculty of Law, Universitas Indonesia.
In today's session, we will continue to discuss various issues related to the main theme of the 6th IcLave.
Before we proceed further, let us reintroduce ourselves. My name is Farhan, and I'm here with my co-host.
And my name is Nita. We will be the master of ceremony for today's conference. On behalf of the organizing committee, we also would like to welcome Mrs. Dr. Kurota Ayuni, SH MCDR, as the 6th IcLave chairman. Our speaker for today's conference, Mrs. Professor Dr. Sulistiawati Irianto from Universitas Indonesia, Mr. Dr. Jeremy Kingsley from Western Sydney University, Mr. Professor Dr. Jeff Giddings from Monash University, and all of the participants of the International Conference on Law and Governance in Global Context that attend today's conference.
Today, we are gathered here in the Interdisciplinary Legal Research Center building, the newest addition to the Faculty of Law at Universitas Indonesia. This building will serve as a hub for interdisciplinary legal research.
That's right, Achan, and it's truly an honor for us to welcome all of the speakers and participants of the 6th IcLave in this remarkable building.
Now, without further delay, let us begin the seminar sessions. This part of the program will set the stage for today's discussions and allow us to explore our conference themes in a greater depth. Ladies and gentlemen, please welcome our moderator for this seminar session, Mr. Aristo Pangaribuan, SHLLM PhD. To Mr. Aristo, the floor is yours.
Let's give applause for Mr. Aristo.
Okay. Good morning, everyone. Thank you for the introduction. So, as the name suggests, we will be talking about interdisciplinary approach of law. So we have all distinguished speakers here. First is the authority in Law Society of Indonesia scholars, Professor Sulis, and then Dr. Giddings, Professor Giddings from Monash University. His research focus, I briefly read your dissertation about these clinical legal education, bridging practice and theory. And we will be hearing your insights today. We're grateful for that. And then Dr. Kingsley. So I also read briefly your dissertations. So Dr. Kingsley research focus is anthropological aspects of law with focus on mediating conflict in Lombok, the cooperation between state actors and non-state actors. So without further ado, I invite the speakers to join me and present the discussion. So this will be one-on-one basis, I believe. So the first speaker will be Professor Sulis. Please, the floor is yours.
Good morning, everyone. It is a great honor for me to be here with you in this very special occasions. I'm waiting for my PowerPoint. I'd like to present my paper entitled The Importance of Interdisciplinary Study of Law for the Future of Legal Education. This one. Oh, sorry. Okay. I'd like to start my presentation with an illustration what is missing from Indonesian rule of law today that needs socio-legal studies as a tool of analysis. And then I would like also to underline the the future trend of knowledge in the global world is cross-disciplinary approach. It's because the digital technology and intensive global migrations drives the, the cross-disciplinary studies. Um, the, and the values of legal development and injustice needs also explanation from social legal studies. And the faculties of law, school of law needs to produce lawyers plus for the near future. And why social legal studies? And I would like also to introduce the main important concept in my literature, that is legal pluralisms and globalizations of law. And I would end up these presentations with the future of legal educations. What is missing from the Indonesian rule of law? The centuries-long rule of law debate since the time of Plato and Thomas Aquinas shows that the concept of rule of law is never singular. It seems that its meaning is changing over time, place, context from author to another. The definition of rule of law in various countries is contextualized depending on historical, political, social, economic, and cultural factors. However, it is agreed that the rule of law is the umbrella of all legal instruments that protect citizens from the state power. Power is bound by law, since Plato and Aquinas. And the second, rule of law protect the property of citizens and threats from other citizens in Enlightenment era. From this debate, Adrian Bettner in 2010 identified there are three categories under the rule of law concept. The first is procedural category or democracy. State officials are supposed to make laws based on the law, not based on the interest of power. But what is happening in Indonesia? Currently, the law is used as a tool for political engineering for benefit of those in power and nepotism. Although legally it looks legitimate, but ethically it is problematic and against to the public's perception of justice. The second substantive category, the substance of the law should be human rights, and now it should be added with ecological justice. What is in reality in Indonesia? We still have many humanitarian law cases that never go to trial. And the third category, controlling mechanism, that is independence of the court. But unfortunately, during the outgoing regime, the Jokowi's regime, we lost the independence of the courts in many judicial decisions. And now I would like to convince you with the importance of social legal studies by illustrating the future of global science that is cross-disciplinary. Digital technology, artificial intelligence can replace almost every work or job which is repetitive and formatted, like drafting and evaluating a contract, drafting and analyzing a legal opinion, processing case trial in the court, and providing evidence. There is a Professor Richard Susskind with his two books, The End of Lawyers, Tomorrow's Lawyers. He said that the legal world will grow faster in the next 2 decades than be employed. The results of such studies can be used to construct arguments and demonstrate the logical fallacy of articles of law and judge decisions based on the realities and experiences of justice-seeking communities. It helps to understand how the law works in society, how people respond to the law, and even how people have the capacity to create their own laws. Now, I would like to introduce you another concept, legal pluralism, from legal pluralism to globalizations of law. State law is not the only reference for behavior. There are always other laws. Legal pluralism classically defined as a coexistent diffusions between legal systems in a particular social arena. Let me give you the picture of legal pluralism in Indonesia. Customary law intertwines religious law, come up with a new laws. We call it adat basandi secara basandi kitabullah in Minangkabau, in West Sumatra, but there are many more regions have their own combinations between the customary law and religious law. How about if the customary law absorbed by the state law? We can find out in a judge decision on inheritance dispute in West Sumatra, for example. And how about when the religious law meets the state law? In Indonesia, we have compilations of Islamic law through InPres, instruction. What is the abbreviation of InPres? Instructions of precedence, yeah? Yeah. What is happening in the diffusions of law? There will be contestations, but also intertwined reproductions, and a new law absorbed into the existing one. The globalizations of law through time and space. International law that intertwine national law through ratifications of international conventions, especially in the field of human rights and ecological justice, we call it globalizations of law. The ideas originally comes from delegations of the states, goes through law-making process in the UN, United Nations, and ratified by the states. We can see that the character of diffusions of law is not only centrifugal, but also centripetal. Then international law and transnational law penetrates into state, local, and grassroots areas. The humanitarian interventions, promotion of democratic values, rule of law, and transnational accountability becomes shared common laws for people around the world. The characteristics of the contemporary global world is now borderless state and borderless law. But global law is also influenced by local law. Local laws and principles are partially or fully adopted in international law. For example, ADR principle, alternative dispute resolutions, borrowing modes of dispute resolution in the local level. Another example, Article 14 of the CEDAW Conventions, contributed by Ibu Suwarni Salyo from Indonesia. Now we can see that the definition of legal pluralism is changing over time. The first, we just define legal pluralism as the coexistence between the state law and non-state law. But now, it's mainly understood as the coexistence of state, international, and transnational law, and the questions of whether such transnational connections influence state law at the national level. And it means that it's not enough only to make a mapping of legal universe. And now, this is the final slides. The future direction of legal education. It needs to produce legal professionals with strong basic legal knowledge and legal skills, but also the ability to build a culture of justice. A legal profession capable of upholding the rule of law without compromising social justice. Law students are not only equipped with knowledge of legal doctrine and dogma, but also interdisciplinary legal studies. Let me add with a brief history. The Indonesian and Dutch legal systems share common legal roots due to colonial history and the long legal cooperation between the two countries. Paul Scholten was the first rector of the Rechtshogeschool, whose establishment was preceded by a long debate between the Dutch government and Dutch East Indies government. It seems easier to decide to establish a Technische Hogeschool, engineering school in Bandung in 1920 and a Geneeskundige Hogeschool or medical school in Jakarta rather than a law school, Rechtshogeschool, in 1924. There were political and social issues involved, such as whether graduates of Rechtshogeschool in Batavia would be equal to those in the Netherlands and could be employed in government institutions at that time. After a century, it is clear that the law in the two countries has developed in different directions, perhaps because Dutch legal texts stopped being translated a long time ago and their development could not be followed, like Professor Andre mentioned yesterday. Meanwhile, various schools of thought and important concepts of Dutch law are still used because the Indonesian legal system is a Dutch heritage. In this situation, there may be distortions in understanding and translating Dutch legal concepts or terms, both in university and in legal practices. In the Netherlands, judicial decisions or jurisprudency play an important role as a source of law, not only filling in the gaps left by legislation. Judicial decisions also serve to assess existing regulations and government policies by considering principles such as equality, fairness, and proportionality. Thus, in the Netherlands, there is an attempt to combine legal certainty with social justice. Law faculties in the Netherlands play an important role in the creation of jurisprudence by discussing and evaluating important new judgments. In Indonesia, jurisprudence has not yet achieved the same status as Dutch jurisprudence. This is because legal academics and practitioners are still very law-centered in their legal analysis and reasoning. Court decisions or jurisprudence rarely achieve the status of binding norms. Most jurisprudence can be overruled by judges hearing complex cases afterwards. The result is inconsistency and legal uncertainty. Through law school education, legal practitioners have been trained to position themselves as only mouthpieces of the law, and that is the cause of the legal vacuum. Law schools in the Netherlands not only teach students basic legal concepts and dogmas, but also how they are applied by judges in real cases. Students are not trained to memorize black and white laws, but to solve legal cases. Hence, more and more law curricula in the Netherlands are adopting subjects that link legal issues to social, economic, and political development, thus making the law come alive. Case analysis is also important for Indonesian students. Through A good understanding of the law is important, as these legal texts provide legal norms intended to protect society from crime and greed and to resolve legal disputes between legal subjects. However, there will always be a gap between the law as written and the law in practice. Legal norms only come alive when applied to cases that arise in society. However, there have been positive development in law faculties in Indonesia in the last 2 decades, as some law professors increasingly use case analysis in their teaching methods. In addition, more and more campuses are offering courses based on multidisciplinary or interdisciplinary approaches to law, particularly with regard to law and society, as well as with a gender justice perspective. Despite the current resistance to change, effort to improve the study of law in practice that takes into account societal justice are gaining ground. Okay, that was my presentation. Thank you very much.
Thank you, Prof. Solis. What a amazing insights for all of us. Again, Prof. Solis, as one of the pioneer in law and society in Indonesia, consistently promoting the approach, the need to put a law, situate the law in context. She just reminded us that there is something missing from Indonesian legal education. And sometimes legal scholars, students, professors often too focus on formalism. And if it remains that way, the ghost of authoritarianism, like you said, the state of power will haunt us back, will haunt Indonesia's back. That is why in this modern day, we need to produce a plus lawyers that can situate the law in context and promote the interdisciplinary legal studies. Thank you again, Professor Solis, for the insights. I welcome the second speaker, Professor Giddings from Monash University Law School. The floor is yours, Professor Giddings. Please give Professor Giddings an applause. Whatever convenience for you. It's too much, huh? Okay. Can someone help him to, okay. So we will be hearing about clinical legal education today, bridging the theory, the gap between the theory and practice in legal education. Please.
Thanks very much. Hello. So some slides, and I have some questions for you. So please, I hope you find it interesting. Okay, back again. Here we go. So I'm talking in relation to a book that I've been working on for a long time, which will be published in January. And I've got contributions for, it's a book about global clinical legal education. And rather than me writing it all, I've invited people who work in this field from lots of different countries. So there is a contribution from Indonesia by Leni Widi Mulyani from Pasundan University. There's material from Japan, Singapore, Taiwan, Thailand, and Vietnam. As far as your region is concerned, as well as many other places. Every part of the world except Antarctica. And there's no clinics in Antarctica. So that's the story there. So I'd like to ask all of you, where do you think we get the first examples of students working on real cases, doing real law as part of their, either as part of their time at law school or as part of their studies in law school? So which of those places do you think? Who would vote for Japan? Nobody. Okay, you're not in a voting mood. Only in the United States. What about Denmark? No? Okay, I'm getting a really great reaction here. What about Russia? What about the United States? So there's a few people who think from the United States. Well, I'm sorry to say that's not the case. Lots of people think that that's right, but it's not the case. From Thailand? No? From France? Okay. The first example we have, you guys are right. It's France. And, whoa, goodness me. The first example we have of students working on real cases comes from 1802, just after the French Revolution. And what do you think the revolutionary government did? They closed all the law schools. But what they did was allow private colleges to work, and one of those, because lawyers were being challenged as well, what the government would permit was students to work on cases. They thought advice from students would be good enough, rather than it having to be advice from lawyers. And in Germany, there are early examples of discussions, professors talking about doing this as early as 1900, but it did not happen until the 1970s. In Indonesia, our first examples are from the 1970s. From Australia, the first examples are from the 1970s. From the Netherlands, the first examples are also from that time. So there's lots of this kind of work where law students can do fantastic things in relation to assisting people to understand the law, and also to assist people in advocating for their interests. So, thank you. And snaps to you guys for getting it right. That's great. I now want to ask, apart from showing off one of my photos, that is of a hummingbird that I photographed in Colombia. It's called the violet-tailed sylph. But I wanted to think about what's the secret, the different thing about clinical legal education in different places. In most countries, people say that we are very committed to social justice, and that's what's special about what we do. That our work is focused not on helping the wealthy and powerful, but on assisting people who cannot take legal steps themselves, who are suffering from various forms of discrimination, marginalisation, and so on. So that's the one big secret spice that everybody says they have. Now, I'm not sure it can be all that secret if everybody has the same spice. So we can think about other things. One of the themes this morning is to talk about interdisciplinarity, multidiscipline work. Well, there are lots of programs in different countries that involve themselves in working with other disciplines. So that is an important part of the work that I do at Monash. We have social work students working in our clinic. We have business students working in our clinic. There are other programs where nursing students and health students are involved in working with lawyers. And this is about changing the way that we understand that the law helps people. It's not the law is the answer. It's not that all these people need is help to assert their legal rights. We need to treat them as people who have a range of needs. And it's much more likely that they will need help from medical services. They will need help from financial counsellors. They will need help from lots of different places. And there are other ways in which we can be involved with other disciplines as well. So, have any of you heard of the street law programs that are run by law schools here? Okay. Well, we run a street law program at Monash based on a model from South Africa, which is really the biggest and best of all the countries as far as that kind of street law, community legal education. And it's great to have students who are studying education and pedagogy, and they come in and work with our students. One of the other secret spices for clinical legal education in different places is that students sometimes set up, sometimes run and manage those programs themselves. It's not about the professors, it's about the students doing it and supporting each other to make those things happen. So there are great examples of that sort of student-led program which you could all be involved in, those students who are here, and you take control in regards to the way in which those things work. It's not a matter of not respecting the contributions that your professors can make, but it's about saying, well, I can make a real difference here. I can be involved in these things. So that's an important part of the way that this can work. Some of the examples that I would give: when legal clinics started in South Africa in the 1970s, it was run by student volunteers. When the program that I am now the Associate Dean for was set up at Monash in the early 1970s, it was student volunteers who were running that. There are now about 80 clinical programs in Germany. About half of them are managed and run by students. Some of those students are receiving academic credit, others are volunteers. So that's a great example. And another example I would give of student-managed clinics is in Norway, where a program was started in the 1970s called Jussbuss at University of Oslo. And that involved volunteer students coming in and working. 10 minutes to go, thank you. It goes so fast, doesn't it? Well, at least it does for me. It's probably taking forever for you. But those students were involved in organising a bus that went out and delivered legal advice and services out in communities. And that's a really important part of some clinical legal education programs, In India, there is a really strong tradition of students going out and spending time in villages, in communities, and providing legal advice, learning from those people. Lenny Moyani has written in the book about the way in which there's a great respect in Indonesian clinics for customary law. And that is a secret spice in relation to your country. And something which I think is very interesting, very different. Another program, another country where there are many students involved in managing and leading an important program is Croatia at the University of Zagreb, where they were influenced by the Juspus example, and they thought, well, we can do that too. And that's what they did. There are lots of places where you can go to learn more about these things and to make that part of the work that you do as part of your law studies. So in the book, I've talked about a range of things in regards to how clinical legal education can involve many different things. It doesn't have to be sitting across a desk talking with a client. There can be a range of other ways in which this is done. And one of the really important things is to involve other organisations to help us. We can't do this on our own, but we can do it more effectively by working with other organisations. Now, I've talked about student leadership. I would say that many people look at clinical legal education and say, well, it started in the United States and we're all doing things that they showed us. I would say that's not right. These sorts of programs have been developed in many places in interesting and different ways. And we should not discount the value of learning. You can certainly learn from the United States, but I think that there's much more to be learnt closer to home. We look for examples within our own countries, within our own regions. So there will be useful examples from the Philippines, from Singapore, from Malaysia that you can use. You could even come and visit us in Australia, and there's interesting examples from a range of universities in relation to the way in which these things can be done. I've put here a list of various sources of information which you can look at that would help you if you had questions about how to run a legal clinic and the sorts of work that you can do. There are very interesting examples from different places. So those are just my suggestions. The other thing is, if you send an email to people who are involved in leading clinical programs, I would expect that they will respond and provide you with, and talk with you as to examples that you could use. So there are new and interesting areas of work which I can see will be important for clinics, whether it's here or elsewhere in Asia, whether it's Oceania, wherever it might be. Climate justice will be really important. On Thursday, we have an event to celebrate 5 years of our climate justice clinic, where the students are involved in lots of different and interesting work which is focused on climate justice issues. very important for us. Technology, artificial intelligence. There's a chapter in the book in regards to clinics and technology, which I think very interesting for us to work on. So I wondered if anybody has a question. If you don't, and that's another photo of mine, the golden eagle.
All right. Thank you for the chance, Professor. First of all, I want to ask especially about something that you note about interdisciplinary action. You've said that the students could basically make their own assessment of their own morality. So in such, they could direct the clinic into, let's say, oh, I want social justice in this way. But how, do want to ask, I'm currently referencing a journal that is made by Alice Taylor about the conflicting purposes for anti-discrimination law, especially in the Australian court. How can we truly define and truly imply to the court what we want? Meanwhile, the court's decision or the court's definition of the law itself is different from ours. So how can we truly adapt their meaning into our own, and how can we truly define our own into theirs? Thank you.
Gee, there's an easy question. I think, thank you very much. I think I'd say that it's a long process that would be involved in trying to change those attitudes and views in regards to these issues. And that's going to be in part about talking with the professors and your teachers in relation to their views on these issues, talking amongst yourselves so that you can figure out what are the best strategies for taking forward cases. You need to identify the right case. But before that, I think there's a lot of work that is usefully done to figure out and share information with the affected communities. So if they are the ones who are being marginalised or facing discrimination, then we need to understand their experience as much as possible. Spending time with them where they live will be really important. And so getting out of the law school, that's not to say that law school isn't important, it is, but it's not the whole story. That would be the way I would look at it. So in 3 weeks' time, I'm taking a group of my students on a tour of the state that we live in, state of Victoria, where we will go out and talk with school students, thank you, and others in relation to sort of issues that affect them. I'm being given the wind up, but I'm going to be very cheeky and ask you a question. Do you think that's a bird that's real, or did I make it using AI? Hands up if you think it's real. Okay, there's a few people up the back who are thinking it's real. Because it is. It might be weird, it might be unusual, it's very distinctive. It's a bird that I photographed in Colombia earlier this year, the plate-billed mountain toucan. And on that happy note, thanks for listening.
Thank you, Professor Giddings, for the presentation and also for the beautiful bird photo. Now we know that you're a, what's that called? A bird spotter? The professions that spotting the bird? What's that called?
A bird watcher or a twitcher.
A twitcher. So we know.
An ornithologist.
Oh, that's hard to pronounce. Okay, a bird watcher. Okay. So apart from demonstrating that Professor Giddings is a bird watcher, he's also giving us an insights, a comparative approach of the global clinical educations. And now we know that it origins is from French. I thought at first it was from the US, but my mistake. And it was shortly after the revolutions, they closed the law schools. Very nice, very informative. I never thought that before. And then we also hear about the examples in South Africa, Croatia, from Zagreb, and then how it's integrated and effectively bridging the legal education in theory and practice. But also, he reminded us about not importing legal education, transplanting from one jurisdiction to other jurisdiction, because we need to put it in context, we need to localize it. Thanks again for the insights, and I would like to invite our last speaker, but of course not least, Dr. Kingsley. Where are you, Dr. Kingsley? Oh, okay. Okay. So, okay, Dr. Kingsley.
Oh, so I'm going, okay. Jeez.
Can you hear me through your
I couldn't, but I'm lucky.
earphone? So you have 20 minutes, and after that we will have our Q&A sessions. Please. You want to use this or your own microphone?
Is it okay? Can people hear me? Yes? Is my PowerPoint there? Yes? Okay. So what I'm going to do is, before we start, you've all been sitting down for a little bit. I want everyone to carefully stand up. Everyone stand up. Carefully do it. Don't knock your neighbour over. Okay. Those sitting down, you have to stand up. I'm not going to do it until you're standing. I'll start pointing you out. It's like in class. Now what I want everyone to do is slowly rotate. Rotate around. Now everyone turn around. Turn around. Turn around slowly. And I want you, while you're turning around, to use your eyes. Because this is what we never do in law school. Slowly turn around, come back. Come back to me, focus on me, I need attention. Sit down now, everyone. Focus, thank you. Terima kasih. Now, when I was in Lombok and I came to Indonesia for the first time, I was always really surprised that at the start of every speech by my kiai or my tuan guru, he would always start by mohon maaf, or I'm sorry. And I was always, he never had anything to be sorry. I mean, he was a really gentle person, really wonderful teacher, you know, if anything, too perfect. So why did he always apologize when he started to speak? And we discussed this over a long time because it never made sense to me. Being a bule, being a white person in Indonesia, whether I thought it or not, I always thought I was right. Okay, and I wasn't. And I'm going to say the same thing about legal education. To all of the students here, we are failing you. To all of the docent here, we're not doing enough. And the reason we're not doing enough is because we're in a period of major change. Now that's probably been said by all law lecturers, all academics for centuries. But at this particular time, it's true. And that doesn't matter whether you're talking about a digital disruption and the consequences for law. That doesn't matter whether you're talking about environmental issues. That doesn't matter whether you've lived in Melbourne, Australia, like I did before I moved to Sydney, and suffered through 1 year of lockdown out of 2. So 1 full year of lockdown out of 2, during a pandemic in which we closed our borders. i.e., I could not hide, my family could not hide from a disease which jumps borders irrespective of how tightly we shut the border. Our regulatory structures leak. In that context, when we're starting to think about law, it is no longer acceptable to say socio-legal and this building is a good example of that, it is no longer acceptable for us to say socio-legal thinking is just a nice value add. It's not really what we do in law school. What we do in law school is positivism. What we do in law school comes from a text, we read it, that's that. It's actually, that's the problem. It's a problem for students who think when a teacher steps back and says, I want you to think, they go, why aren't you giving me the information? It's why lecturers who only refer to statute or only refer to case law are doing a disservice, because the reality is that that is no longer the sort of matrix which will have any form of success in our education. And so in my discussion, I emphasize this idea of immersive and experiential learning. And maybe I'll pause. When I'm talking about immersive and experiential learning, I'm talking about study tours, field schools, clinical education, exchanges, etc., etc. All opportunities which involve my students standing up and looking around. And what's more is when they're standing and looking around, that's not enough. I'm sure for all the students, Masiswa here, you have all heard your lecturers say to you, I care about what your opinion is. And usually we kind of mean that. We mean it in regards to we think there's 3 or 4 correct answers, and we want you to give us one of those answers in an educated manner. But that's not good enough. That's not good enough for you, and that's not good enough for me. Because why I talk about immersive and experiential learning, what I am talking about is saying, I want you to stand up, I want you to look at what's going on around you, whether it be in a kampung in East Java, or the Supreme Court office building in Jakarta, Mahkamah Agung, or whether it be a case in a district court in Banjarmasin. Doesn't matter. Why doesn't it matter? It doesn't matter because the input, the data that you're seeing, usually we don't really care about. We don't incorporate that into our learning. However, the real learning is when we start to say, what happens in the Pengadilan Agama, Kota Mataram? Why are there no cases of pencurian or theft when the whole of the rhetoric in the political sphere is talking about theft and how terrible it is in Mataram? Why is there a disjuncture? How are disputes being resolved? Now, I'm going to refer to a person who's passed away. This is him sitting somewhere probably in Central Java. It's Clifford Geertz. Central Java, we don't actually know where it was, although there's lots of probably presumption of where it was, or in Bali, if anyone's read his material. And the reason that I am putting the word ethnography there is to say that we need to change what is at the core of your legal education. What do I mean by that? Often we talk about lofty concepts. Often we talk about we have to change the structure of doing this. We have to change the curriculum there. But I'm going to go basic. I am going to suggest to you that we need to start saying, how do we incorporate ethnography, or a thick description, a deep rendering of a situation? How do we give it meaning into a legal analysis? So Clifford Geertz talked about a cockfight. If anyone's read him, you should have. Very famous ethnography of a cockfight in Bali, in which the cockfight is really kind of irrelevant. What is relevant is the interactions between the people, the officials, the police, Everyone. What happened? How did it happen? Why did it happen? And what you learned in that cockfight was a series of social interactions. Those social interactions didn't just tell you about a particular discrete incident in Bali, but a particular way that people engaged with the law in Indonesia. Now, of course, you can't extrapolate a particular circumstance to mean everything, but it does inform legal analysis, and it informs legal analysis more than the throwaway line of giving something context. Lots of legal scholars will tell you in your class, give it a little context. And what they mean is, if you're going to be talking about the fall of President Suharto, let's talk a little bit about the economic crisis. Let's talk about a crash in the currency. Let's talk a little bit about the momentum of the student movement, which came and took and sort of really challenged power at a particular point. All of these are valid contextual issues, but they don't go into an explanation of how and what happens next. We need to add more depth. So, when we add depth, we're talking sometimes in a contradictory sense. And I'm going to talk about the contradiction after I explain a few things. All of my initial research on Lombok was about this idea of local governance. I used a conflict to illuminate the circumstances. It wasn't about the conflict actually. So what I was interested in is this, and it's a very particular situation. In the years immediately post the fall of Suharto, there was a series of ethnic, religious, political conflict. It sprung up at different times in different places. But if you look at the Human Development Index, Lombok is actually one of the poorest parts of Indonesia, just literally above Papua. Now, and Papua defined broadly, the three regions. Now, what I mean by this is that theoretically, when they had violence in early January 2000, I was intrigued. Why did this area, primed for very serious violence, erupt into violence, but did not have three things? Did not have any murders or killings, unlawful killings, that we can trace. That's important, we can trace. Did not have, and I understand and apologize for saying this, sexual assaults which had happened elsewhere. And finally, did not even have assaults against the minority Chinese and non-Muslim residents of the island. So why was there was a lot of what we would class as property damage, but there was not, this is important, there was not that physical violence which had happened elsewhere. And why did that not happen in an environment when it should have happened? The common conflict literature says where there's more poverty, there's more violence, and it's sort of combustible. But there wasn't. And so I was interested in what in that local governance arrangement meant that there was violence, but it was able to be limited. So I don't mean property damage is property violence, theft, destruction is okay, not at all. But why didn't it go that step further? What stopped it? So, and I had to look at this idea of local governance to get there. But then I said, if I want to make an analysis of this local governance, how do I do it? How do I explain the role of Tuan Guru, Kiai, religious leaders on the island? Why were they so influential? How did they use their influence? Because it's not just they're influential and they stood up and said, how do they use that influence? How do they inform and enforce their will? Because it's inform and enforce. And to do that, I looked at this idea of fabric of governance. And this fabric of governance comes out of an interesting debate between two medieval scholars. One, a Jewish scholar, and one an Islamic scholar. Ibn Rushd and Maimonides engaged in a series of letters between themselves. These letters discussed the idea that you could create a tablecloth for understanding laws, a fabric. And they discussed it, Ibn Rushd most importantly, discussed it in relation to understanding that to make up law, to make up the fabric of society, you needed to weave it together. And you see that in the different traditions. But this came out of an unlikely, what we would today, due to our politics, see as an unlikely connection. But in medieval times, it wasn't unlikely, because jurisprudential scholars would do this communication via letters. So I built up this idea of a fabric of governance. And it's not just non-state and state actors, but about the way they work together. The way they institutionally work together, the way they individually work together, and the way that their rulemaking combines. And a lot of my black letter law scholar colleagues freak out when they hear this. Why would you have this fabric? This fabric of governance is danger. No one's going to be able to understand it. No one's going to be able to apply it. And it's not true, and it's not real, and it's not what law is. So, all I do then is I point to a very, very conventional form of law, international commercial arbitration. In international commercial arbitration, you make a contract. You say you are going to you're from Australia, you're from Indonesia. You say we're not going to trust either domestic court. We are going to contract out of the sovereignty of either the Republic of Indonesia or the Commonwealth of Australia. That is a major change to any notion of sovereignty in any Westphalian state. But we accept it as a legal fiction. So what I'm saying to you today is, we create legal fictions to deal with our reality. When you're creating an ethnography and therefore and trying to build a legal ethnography of a time, a place, and include it in legal analysis, my answer was a fabric of governance. You can see it in adat practices, such as the joget here. You can see it at international commercial arbitration. Doesn't matter. Same thesis, same argument. And that thesis and that argument is why, even though this very local assessment bonds with the global and the transnational. Because I have seen the same things in practice, not just in this community in Kota Mataram, but when I've worked with law firms and lawyers in Jakarta or Dubai. And that is that they are all weaving a fabric of governance, which rolls in and out of states, in and out of non-state and state institutions. 5 minutes, I'm almost about to wrap up. So, I've laid out this hypothesis. I've said ethnography and anthropology, we've got to do it. What does it mean? Well, it sets a challenge for the docent, the lecturers, and it sets a challenge for the masters by the students. And this is a mutual challenge. If we want to understand how and I was a corporate lawyer initially. That's my penitence for and why I've done lots of years of trying to do good in the world. But being a corporate lawyer, I realized that I had to understand the social and political priorities of my client before I could operate. It didn't matter the corporate law in Australia. What I had to know first and foremost was, what did my clients, who, by the way, I'm in Indonesia, who were Indonesian, what did they want? Why did they want it? Why did they have priority within families and not within the listed company? Why, so anyone doing corporate law here, why in Australia when you do capital markets are you talking about a tax issue and not a raising funds issue? i.e. different priorities, different interests as to why you do things. The challenge to us is to start empowering you as students to understand and take control, whether it be in clinical settings, or whether it be in field schools, in to understand and to use what you see with your eyes as legitimate. Now, that takes work from the student, because what that means for the student is that you actually have to do a lot of really hard work. But what it means for lecturers and professors is that we have to think through how we guide you through that hard work. How we explain a legal analysis which doesn't just end at what is in this text, but ends also in what you see and then thinks about through, for instance, a fabric of governance, what that actually means, how you apply it. And on that note, I think it's a fair place to end it today. Thank you. Terima kasih.
Thank you, Professor Kingsley, for an amazing insights and understanding of the fabric of the government and society in Indonesia and in Lombok. It seems true that Indonesia has become an inseparable part of you. Is it true that you also, because of your deep emotional connection to Indonesia, you cried while you were on the plane?
Yes.
Was that true?
Yes, it is true.
Say,
Many times. How do you know?
I read your dissertation. The first
You
part.
did read it? Oh my God.
Of course, I did my homework. So please raise my salary, okay? Just joking. So Professor Kingsley highlights about legal ethnography, how it is important to be immersed into your legal research, become one with the community, with the society, to dig deep the cultural values. Professor Kingsley also mentioned about Clifford Geertz in his famous works, The Cockfight, that displays it more than a cockfight. It displays the ritual, power, status, values of Balinese traditions, and deep play about the betting. That he wants us to do, especially docent, law professors. We need to teach students how to be immersive, experiential in learning, and dive deep about the, not just on the surface of the law, but the meaning behind the law itself. And Professor Kingsley also discussed about his own work, about the role of Tuan Guru in managing conflict, suppressing violence, and the cooperation between the state actors and non-state actors. Lastly, he also highlights about the need to understand through the legal ethnography, we can understand the fabric of the society, the fabric of the governance. And I like the term, the tablecloth. I mean, that's very interesting. So you can design, you can see the cloths, the map of the law itself. Okay, and now we have a Q&A sessions for 30 minutes, yeah, Bu Ayu, until 10:30. So anyone can raise your hand, and for the presenters, you can do as your wish. You can be here at the front, or you can speak at the sofa. But let me first go to the spectators first, and then we accommodate the questions first before coming to the front. Is that okay? So the first question from, please introduce yourself, Pak.
Okay, thanks very much. My name is Professor Yusuf Henuk from Unstar, University Nusa Lontar in Rote Island, next to Australia. My question is to Kingsley, how about the cockfight? We can regulate to become a good, good cockfight in Bali? Yes. In your idea, how the law, we can produce a law to make the that one become like traditional in Indonesia, or what? From a law perspective. Thanks very much.
Please, you can answer directly. I think one by one, and then we can go to another questions.
So the interesting thing about the cockfight and what the cockfight tells us is the question of, how you enforce a ban on something when the culture, the tradition around it doesn't see it as a problem. So when there is a disjuncture between the law and the society, and that's not uncommon. So when you, and the thing that I would say, the interesting thing about the cockfight analogy is to go, okay, how to look at quite in a hard and serious sense, how does the society and the state engage in mediating challenging situations? So let me give you another example. One of the challenges when I was in Lombok, we went to a court, and I said, the Pengadilan Agama, or the religious court, the family court, and my partner, who's an anthropologist, the better half of us, she was asking the judges, what laws do they apply in relation to divorce? Because she was interested in the life cycle of marriage and divorce. And they said, oh, well, we use traditions. And I said to her, but they've got a compilasi hukum, or a compilation of Islamic law. How does traditions in Lombok work with this? And they said, the judges just exercised a discretion in the way they interpreted it, and that's life. What I think is we sometimes do, we sometimes miss, and this is really important for law students and also lawyers, is we forget what the law is. Instead, we want to imagine what the law is. We imagine corporate law is like this, but it's not like that. We know that regulators in certain jurisdictions will look at certain things one way and not the other. So what I would say to you is the importance of the cockfight, as the importance of any ethnographic insight, is just to help us understand how society interacts with law or ideas of law. And that's what it's all about.
Thank you. And Professor Adik, please.
Yeah, thank you very much for the three presentations this morning. I have a question for each of you, but perhaps of the time of course I start with Professor Sudi. Compliments for your presentation. It was very well in the sense of presentation as such, but also in relation to the contents. And I know you as a kind of making a link between legal and non-legal issues in the study. And one of my questions is, so I will not speak about the publication of Adriaan Bettner, etc., but one of the questions for me is, you know, I'm more traditional lawyer and you are a more modern lawyer. How are you dealing with situations of unwritten law? Unwritten law where when you look at it from a more social science perspective, it's only about the factual situation and not on the legal situation. So it's interesting how you in your study are dealing with non-written legal issues like principles or theories or whatever. So that's one question. I had a question also to Professor Kingsley, Jeremy, sorry. I also worked together with Mataram University for several times and also in the law faculty there. I have heard, of course, your presentation. My experience on Mataram University, the big problems, legal problems at this moment are the environmental issues, the mining in the issues, the tourism issues. And I didn't hear at all these issues, which are from a legal perspective very relevant. I didn't hear about it. So that is my question. What, perhaps I did not listen well your presentation, or I have to read your book and then I will understand it. And then finally, the colleague from Monash also a question. Yeah, you were asking how is that with that clinical legal education? I'm afraid you did not study in your book, but I cannot read it because it will be published in 2025. You did not study the clinical legal education in especially Latin American countries. in Latin American countries. I worked for a long time in several, all the Central American countries. In Bolivia, I worked in Venezuela. So I know they have already from the beginning a clinical legal element in their legal study. So I was wondering, why don't we see that in your list with questions? You're asking about Russia, you are asking about France or Germany. And I did my study in 1974 at my university. We did at that moment already clinical legal research with cases, of course. So I'm afraid you have perhaps a different view on clinical legal education. Perhaps it is also because you are speaking about global clinical education. So the word global can mean different things. So I was wondering, perhaps I missed already also some points of view. But all the three very interesting. Thank you very much for your information.
Thanks. So, yeah, professors will answer first. Okay. So the question to all of the speakers.
Thank you very much, Professor Heng Ading. It's very interesting questions. Concerning the unwritten law, as a legal anthropologist, I would say that for me, law is not limited to the written sources. Law is the anthropological or sociological living documents. Even the society or community has capacity to create their own law. We can find out in daily life of the society, almost every day, there will be dispute or conflict. Nancy Tanner is the one who wrote a book in West Sumatra, for example, where the dispute settlement occurred. She said, in the malls, in the backyard of the school, in the Balai Desa village assembly, yeah, they didn't go to the state court, yeah. I would also add my answer with my experience. I have been using legal ethnography for my research, and I use this method, legal ethnography, to study courtroom. Yeah, the way I did is that I just sitting in the courtroom and listen all the dialogue, all the hearing, and I'm in the opinion that everything I see, everything I listen, everything I observe is very rich data of law. And after the trial, I go outside the court and I interviewed or observe the parties involved in the dispute. I interviewed the lawyer, even the judges. And in so doing, after the judge decision come up, I can check why the considerations of judges, why the decisions of judges is like that. And I can explain because I testified, I have the rich data about what is going on during the trial. Thank you.
Then Professor Giddings first, answering Professor Iding's question.
Thanks very much. Gives me an opportunity to talk a little bit more about the book. I did mention the Netherlands as developing clinical legal education in the 1970s. So you're one of those pioneer students involved in that work. So there were the law shops and various other forms of clinical legal education that operated in the Netherlands. There's a whole chapter on Latin America in my book. So there are contributions from 6 different countries. So probably the earliest of those was Chile, where there were clinical legal education programs that started as early as the 1920s. And it's really interesting to think about how those programs continued to operate through a very repressive military dictatorship and the challenges that that generated for them, but they continued and they flourish now. So there's a great piece from, it's referred to as Clinic in the South of the South, which is from Temuco in the very south of Chile. There's a contribution from Brazil, which talks about lots of different types of work being done by law students, but known by other names. So there's Consultario Jurídico in Colombia and similar arrangements in Brazil. There's also a contribution from Argentina, which I think is, again, sort of very helpful in assisting us to understand how these programs can operate effectively in the face of a military dictatorship. And that really changes the way that they work. And there's also a great piece from Mexico. I asked the author from Mexico, would you like to be included in North America, or do you want to be part of Latin America? Latin America. And that was her view. And she very interestingly talked about the fact that there's several thousand law schools in Mexico, and very few of them have taken up clinical legal education in a systematic way. But the law schools that have taken up that work are all ones that are prestigious and can see that that's a really important part of broadening as well as deepening legal education. So thanks for the question.
Okay. I don't know which one.
You want to use that, mate? I'll just get rid of this.
Of course, any ethnography misses issues. Of course. And in Mataram at the moment, one of the biggest issues, which really exploded about halfway through last year, was the UN Rapporteur on Human Rights report about land displacement. In relation specifically to the Mandalika development, tranche, I think it's like 3 or 4, which has meant that there was a dispossession of a significant number of local people. But that's not the first land displacement. The first land displacement in this big tourism boom happens in 1992, when they displaced people around the new international airport to clear the land for that development, which didn't actually open up until 2010. These issues of land displacements and let me clarify that. I don't want to say land displacements. Let's say highly political land disputes. Because the reason that I use that terminology is that there is an argument. The argument in Lombok is that all of these land disputes have been documented in a strict legal sense perfectly. There has been a transfer of money done under contract with evaluators. The question is, how fair were the evaluators and how much freedom did the people who signed the agreements, you can say signed the agreements or were displaced, how much freedom did they have in the signature of those documents? That's where the UN Human Rights Rapporteur has become involved, and that is why this particular issue now is so hot. In fact, it is so hot that the Chinese Investment Bank, underpinning this particular funding arrangement, is considering whether to give, I think it's 3rd and 4th installments of funding. So it is very, very political now. You're exactly right. But what I was interested in was just a different particular time and a different particular issue, because I was looking at this in 2007, really till about 2014, with what happens in the wake of reformasi, in the wake of democratization and decentralization. Obviously now, new and hot issues about land displacement are taking place. The issues of mining, a lot of those relate to Sumbawa and further along. But in Lombok, it's around Mandalika and around the international airport. But yes, they're very, very hot issues.
Thanks for the answers about the Lombok situations. I think because we started late, can we accommodate one more question? Is there any? Okay. Please.
Thank you. First of all, I would like to thank our presenters for very interesting and engaging presentations. My question is to Jeremy in particular because he has been working in Indonesia where legal pluralism is actually applied. When you go down to the village, to the communities, I wonder which type of law prevail. You know, which one is because you got so many laws there.
So talking about immersive learning and experiential learning, this is good for, I'm going to take my Australian students here and explain to them. When I take my Australian students to Indonesia, I say, there are 9 levels of government. RT sampai the state, right? The negara, you know, the president. So if you look at it, there's 9 levels. In Australia, we have 3. So what is dominant? What I would say to you is that the state and the non-state, absolutely every level is important and they're in play. So let me give you a very high level discussion. When they choose the ministers of the Republic of Indonesia, who takes the head of Mora? Where do they come from? Where does the head of Mora come from? It comes from one place. Where? Indonesians, you must know. Where's the head of Mora going to come from, the minister? What's the background? Sorry? Religious, where's the head of the Religious Affairs Department, the Ministry of Religion? Where's the minister going to come from? Exactly. Nahdlatul Ulama is the largest non-state Islamic movement in the world. So from the bottom to the top, these play out. I'm not going to be involved. It's too hard to say which is dominant because it plays like a dance. I never believe the state is irrelevant. I never believe the non-state is all powerful. What I say is that they depend on each other. That's why it's a fabric. Because they sort of weave in and out. But at all levels, from non-Indonesians, RT is about your local 2 or 3 streets. So 200 to 300 citizens. So if you're living in Indonesia doing an exchange, you would have almost certainly had to meet your Kepala RT because they want to check you out. Right? And if something happens to you, who do you go to? You go to RT, RW, usually. Maybe go a little higher. But usually those. So what I'm saying is it's always a dance, and RT and RW are state and non-state simultaneous, even so. Anyway, that's my answer. No answer.
So the key word is, it is a dance between the state actors and non-state actors. So please join me in giving applause for the speakers again. And we conclude this discussions. Thank you again for the speakers and also the observers. And I'm giving back the floor to the MC. Please, the floor is yours.
Okay, once again, give applause for Mr. Aristo for leading our moderation session. And then for the next session, we also want to thanks to Professor Sulistiawati, Professor Giddings, and also Dr. Jeremy for their insightful presentation. And up next, we will announce the participants of the 6th IcLave who have been selected as the best presenters.
Yeah, this is an exciting news because we have 5 best presenters chosen based on the quality of their presentations.
That's right, Nita, and I'm sure all the participants are eager to hear if they have been named among the best presenter of the 6th IcLave.
All right, let me begin announcing our best presenters. For the first one,
Okay, we wait for the
have-
video.
okay, let's just wait for a second.
Okay, let's go, Nita.
The first best presenter of the 6th IcLave 2024 is Tirta Wening from University New South Wales. Give applause.
And our second best presenter is Dodit Setiawan Nur Haryanto from Universitas Islam Indonesia.
Next, we have Aditya Wiryansyah from Indonesia Judicial Research Society.
Our fourth is Yancha Arizona from Universitas Gajah Mada.
And last but not least, we have Ramalina Ranaiko Mikea Manitra from Universitas Indonesia.
Once again, give applause for our best presenters, for this 6th IcLave. And also we want to say we extend our congratulations to all the participants selected as the best presenter at the 6th IcLave. We hope these recognitions provide even greater opportunity for each of you in the future.
Once again, we extend our congratulations to all participants selected as the best presenter at the 6th IcLave. Next, we will proceed with the reading of the recommendations or statement from the 6th IcLave 2024. For this, we invite the chancellors and esteemed professors from the Faculty of Law, Universitas Indonesia, to join us on stage.
And following the reading of the 6th IcLave recommendation, we kindly ask the Chancellor and also all the professor to remain on the stage as we will proceed with the tree planting ceremony to commemorate the conclusion of IcLave and celebrate the 100 years of Indonesian higher legal education. For our Chancellors and esteemed professor, the floor is yours.
Pasatnya. Ya, bututin nggak? Oke, thank you. Profesor Harvisuti Harskrisnowo, SH MA PhD, selaku Ketua Dewan Guru Besar Universitas Indonesia yang hadir kemarin tapi tidak hadir mungkin hari ini, atau yang mewakilinya. Yang terhormat yang terhormat Profesor M.R. Andri Gunawan Wibisana, SH LLM PhD, selaku Wakil Dekan Bidang Pendidikan, Penelitian dan Kemahasiswaan. Yang terhormat Profesor Dr. Satya Arianto, SH MH, selaku anggota Dewan Guru Besar Fakultas Hukum Universitas Indonesia. Yang terhormat Profesor Dr. Randa Sulistiawati Irawanti, MA, selaku Guru Besar Fakultas Hukum Universitas Indonesia. Yang terhormat Profesor Dr. Jeffrey Giddings, Associate Dean of Experiential Education, Faculty of Law, Monash University. Dr. Jeremy Kingsley, which one? Okay, sorry. As Associate Professor and Associate Dean International at the Western Sydney University Law School. Professor Dr. Sri Papa Padmasri, sorry for mispronounce. Para peserta konferensi, Profesor Heng Ading, from Utrecht University. Okay. I did my PhD at Utrecht. No, not my PhD, but part of the research of my PhD. Okay. Para peserta konferensi yang saya banggakan dan tentu saja para kolega, para mahasiswa, Assalamualaikum warahmatullahi wabarakatuh dan selamat pagi. With due respect for the international participant and this event, I would like to address the declaration of Asta Dharma to reflect on the 100 years of higher legal education in Bahasa. Please allow me. Saya hari ini selaku Ketua Dewan Guru Besar Fakultas Hukum Universitas Indonesia, sebagai perwakilan sivitas akademika, ada Dewan Guru Besar, ada struktural Fakultas Hukum, dan ada juga teman-teman dosen, teman mahasiswa dan juga tendik, ya, akan membacakan deklarasi untuk menutup rangkaian IcLave di Universitas Indonesia Depok. Momen ini menjadi penting sebagai refleksi 100 tahun pendidikan tinggi hukum di Indonesia dan menjaga marwah universitas sebagai rumah tempat memproduksi dan mengembangkan ilmu pengetahuan serta menumbuh kembangkan nilai atau value, dan tidak semata-mata sebagai tempat hanya untuk mentransmisi pengetahuan. Kedelapan amanat ini merupakan sumbangan pemikiran para pegiat hukum di Indonesia, khususnya dalam pelaksanaan IcLave 2024. Asta Dharma Pendidikan Tinggi Hukum Indonesia. Pertama, pendidikan berbasis etika. Kami percaya bahwa setiap pemangku kepentingan wajib menjunjung tinggi etika dalam menjalankan peran masing-masing. Etika dalam pendidikan hukum tidak hanya berlaku pada mahasiswa, tetapi juga pada dosen, praktisi, dan institusi hukum. Hal ini bertujuan agar lulusan hukum tidak hanya memiliki pengetahuan hukum yang mumpuni, tetapi juga memiliki integritas yang tinggi dalam menerapkannya. Kedua, jaminan perlindungan dan kebebasan akademik bagi kampus. Kami percaya bahwa pendidikan tinggi hukum harus memiliki jaminan perlindungan dan kebebasan akademik yang bertanggung jawab. Kebebasan ini penting untuk mendorong inovasi dalam kurikulum dan metodologi pendidikan tanpa intervensi yang menghambat proses pembelajaran yang kritis dan terbuka. Ketiga, imparsialitas hakim. Kami percaya bahwa pendidikan hukum harus mampu mendukung imparsialitas hakim, yang mana hakim tidak memihak dalam memeriksa, mengadili dalam memutuskan perkara. Hukum, sekali lagi, hukum tidak boleh digunakan sebagai alat untuk mendukung kepentingan politik tertentu. Keempat, pengembangan keterampilan penelitian dan analisis kebijakan. Kami juga percaya bahwa pendidikan hukum harus membekali mahasiswa dengan keterampilan riset dan analisis kebijakan. Riset hukum yang dilakukan dapat memberikan data dan analisis yang bermanfaat bagi pembuat kebijakan, serta melibatkan mahasiswa untuk meningkatkan pengetahuan mereka. Hasil riset ini dapat menyoroti area di mana hukum masih perlu diperbaiki atau diubah untuk mendorong perubahan legislatif yang lebih baik. Kelima, adaptasi terhadap megatrends dan perubahan cepat. Kami percaya bahwa pendidikan hukum berperan penting sebagai tulang punggung keadilan, pemerintahan, dan transformasi sosial. Namun, dengan perkembangan pesat teknologi, norma sosial yang terus berkembang, dan lanskap peraturan yang berubah, maka sistem pendidikan hukum harus mampu untuk terus beradaptasi. Kurikulum hukum perlu menyesuaikan diri dengan tantangan-tantangan masa depan agar relevan dalam menghadapi dinamika global. Keenam, penerapan model pembelajaran berbasis kasus, case approach. Kami juga percaya agar mahasiswa dapat memahami dinamika praktik hukum, metode pembelajaran berbasis kasus sangat penting. Oleh karena itu, institusi pengadilan dan penegak hukum perlu memberikan kemudahan akses ke sumber-sumber penelitian berbasis kasus seperti putusan dan memahami kasus nyata. Ketujuh, memperluas sumber rujukan melalui studi komparatif. Kami juga percaya bahwa pendidikan hukum perlu lebih terbuka dalam memperluas referensi dan tidak terpaku pada satu patron tertentu. Studi komparasi dengan sistem hukum di negara lain dapat membantu mahasiswa memahami perbedaan perspektif dan prinsip hukum global, serta memperkaya wawasan tentang berbagai pendekatan hukum yang relevan. Dan kedelapan, sebagai butir deklarasi terakhir, pengembangan keterampilan praktis dan kritis. Firma hukum, praktisi, dan pejabat publik sering menekankan pentingnya keterampilan seperti pemikiran kritis, pemecahan masalah, dan komunikasi efektif. Oleh karena itu, pendidikan hukum harus menyediakan kesempatan belajar yang berbasis pengalaman, seperti magang, klinik hukum, dan simulasi sidang atau moot court untuk membekali mahasiswa dengan keterampilan praktis yang dibutuhkan. Demikian deklarasi ini kami serukan atas nama Sivitas Akademika Fakultas Hukum Universitas Indonesia, Depok 5 November 2024, Yeti Komalasari Dewi atas nama Ketua Dewan Guru Besar Fakultas Hukum Universitas Indonesia dan Sivitas Akademika Fakultas Hukum Universitas Indonesia. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi.
Okay, let's give a big round of applause, and we now invite for all of the professors and the chancellor to stay here, and also the speakers and all of the participants that have registered the 6th IcLave, because right now we will not only marking as the
After this, we're gonna have a tree planting ceremony together with all the professors and also all the participants of the 6th IcLave. So we invite all the professor and also all the participants to join us in front of the Supomo building to tree planting ceremony. Kami persilakan kepada seluruh peserta dan juga partisipan dari The 6th IcLave untuk bergabung bersama kami di depan Supomo Building untuk bersama-sama melakukan seremoni penanaman pohon. Also, we invite all the participants of the 6th IcLave to join us in the tree planting ceremonial in front of the Supomo building. And this tree planting ceremony is going to be a meaningful moment because we're not only marking the end of this year's IcLave activities, but also we're celebrating the proud legacy of 100 years of the Indonesian higher legal education.
Okay, at this time, our chancellors and esteemed professors from the Faculty of Law are planting the tree together. Let's give them a round of applause at this truly a historic moment for us all to remember.
Once again, give them a round of applause. Okay, let's give applause for our esteemed professor on the tree planting ceremony, because it's not only marking the end of this year's IcLave activity, but also we're celebrating the proud legacy of 100 years of Indonesian higher legal education. Okay. Okay. Give applause for this tree planting ceremony. Okay. Okay. Thank you so much for all the professors, all the speakers, and our guests. Okay, and next we welcome Dr. Jeremy Kingsley, and next
We have Professor Dr. Jeff Giddings from Monash University.
And also Professor Edding from Utrecht University has also participated in tree planting ceremony for this afternoon. Okay, let's
give a round of applause
for all the professor and all our guests for today's tree planting ceremony. And And after this, we kindly ask all the chancellor and our esteemed professor to return to your seat because after this, we're going to continue our next session in the 6th IcLave. So for all the guests,
We will have a documentation in front of the stage. So we can go back to here.
Yeah, after this, we're gonna proceed with the documentation session. So for all the professors, you can join us in the front of the stage.
And all of the speakers, you can just stay in front to take a documentation. Prof, boleh di depan.
Kami himbau kepada hadapnya kemana ini?
Seluruh partisipan juga dapat berpartisipasi untuk berfoto bersama di depan. Baik, seluruh partisipan dapat turun ke area panggung. Baik, partisipan dapat turun ke bawah, berdiri di belakang para pembicara dan guru besar untuk mengambil.
For all the participants, can join us in the front of the stage because after this, we're gonna take a group photo together. And also,
Baik, mungkin sedikit merapat lagi yang di belakang supaya masuk ke area frame fotonya. Baik.
Okay, everyone, please look at the camera. Okay, everyone is ready to take a picture together? Everyone, please look at the camera and I'm gonna count down for the photo. And don't forget to smile in 3, 2, 1. Great, one more time. 3, 2, 1. Okay, one more time. Don't forget to smile. 3, 2, 1.
Okay, thank you. You can
we
go
invite
back
all the
to your
speakers
seat.
and also all the professors to return to their seats.
Okay.
And then
Langsung aja. Ada
okay, before we close today's agenda, we want to welcome Mrs. Ayu, and also
Prof.
Professor Andri as the chairman and also as the vice dean of the Faculty of Universitas Indonesia to give a closing speech to close this
Closing remarks.
Closing remarks. Okay.
Okay, now we're at the end of the 6th IcLave 2024. I would like to say many thanks for all the presenters here. Big applause for all presenters. And also the big applause, more big applause for all the committee that has support this conference with very, very hard effort. My fail. Very, very hard work, very hard work for last 3, 4 or 4 months. So, and then the last one, I also want to thanks to all speakers for the best insight, for all the material and all the information, and for all discussion that you bring the light for the Indonesia, not only for UI, for all our best university that already present here. And after this, I will say, I will invite you all again to the next year IcLave, the 7th IcLave, and hopefully you'll enjoy more than today IcLave. I don't know. Thank you very much. I give it to Prof. Andri.
Thank you, Ayu. Good morning, everyone. Also, same with you, I would like to express my gratitude for all speakers that are willing to come to here and then share the knowledge and experience, and also for the participants. So it comes as a surprise for us with the number of the participants that join with this conference. We have 100, more than 100, 190 papers. So, participants. So, more than 130 papers. So, I think we were thinking that next year, perhaps we start the IcLave not around Indonesia, but here at UI, because I think the number, is more interesting for many participants. It is more interested to come to UI rather than to other parts. So I would like to thank also for the organizing committee. I will call all of them. Please come here. Ayu, I see, Aim, Sandi, Fitri, Prika, and the students, Mbak Diah, Yvonne, please come here. Satrio. Ayo studennya sini. Gabung lah. Gabung. Mana ada. Ayo. Mbak Bulan. Mbak Patono. Tono. Semua itu yang di belakang. Ayo dong. Alvin. Cepetan, Vin. So, these are the people responsible for the success of 6 IcLave. Please give round of applause to all of them. Ayo. And see you next year in the 7th IcLave. Okay? Ayo, so it's all of us are already here. So thank you again. See you next year. With this, I close the 6 IcLave conference at UI. Thank you.
Bapak Ibu undangan bisa makan di lantai 4, Bapak Ibu semua bisa ambil lift di sebelah kiri Bapak Ibu ya. Silakan bisa langsung ke lantai 4 untuk makan siang. Bapak Ibu peserta semua presenter bisa ke lantai 4, rekan-rekan mahasiswa bisa ambil konsumsi di belakang.
We invite all of the speakers to join us to have a lunch together at the 4th floor of this building. And for students, they can have their lunch at the back. And all of the participants that have registered, you can go to the 4th floor of this building. You can take the lift on the right side. As your master ceremony, we would like to express our sincere gratitude for your participation and engagement throughout the event. We apologize if there are any errors in our words or actions, as it was not our intention to cause any inconvenience. Thank you once again for being us today. Wishing you all a wonderful day ahead. Wassalamualaikum warahmatullahi wabarakatuh. Shalom, Om Shanti Shanti Om, Namo Buddhaya, and salam kebajikan
for all of us.